This is a 90-seater hall.
Oh, this is very nice. And the steps are good. Steps are very good.
They have a similar hall like the ground. Benches are fixed. It's a 40 seater, sir. 40 seater class. Open it, yeah? Right. We go like this.
I like the color of the wall.
Slightly change it. This is a 40 seater class.
ಚಂದನ 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 ನಾಡಿನ ನಾಡಿ ಸ್ಪಂದನ ಚಂದನ 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 ಪಂಪರನ್ನ ಕವಿ ಶ್ರೇಷ್ಠರ ನುಡಿಯು ಕನ್ನಡ ದಾಸ ಶರಣ ಸಾಹಿತ್ಯದ ನೆಲೆಯು ಕನ್ನಡ ಚಾಲುಕ್ಯ ಹೊಯ್ಸಳ ಅರಸರು ಕೆತ್ತಿದ ಕನ್ನಡ ವಿಜಯನಗರ ಮೈಸೂರಿನ ಹೆಮ್ಮೆ ಕನ್ನಡ ಕಲೆ ಸಂಸ್ಕೃತಿ ವಿಜ್ಞಾನದ ಸ್ಫುರಣ ಮಾಹಿತಿ ತಂತ್ರಜ್ಞಾನದ ಕಿರಣ ಜೀವನದಿ ಜೀವ ಸಂಕುಲದ ಚೇತನ ಕನ್ನಡಿಗರ ನರನಾಡಿಯೇ ಚಂದನ 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 ಚಂದನ
ನಾಡಿನ ನಾಡಿ ಸ್ಪಂದನ ಚಂದನ ಚಂದನ ಚಂದನ
I go to Karnataka. Ella is going to make a ಸಂಘದ ಅಧ್ಯಕ್ಷರು ಮತ್ತು ಪದಾಧಿಕಾರಿಗಳು ಗಣ್ಯ ಅತಿಥಿಗಳನ್ನು ವೇದಿಕೆಗೆ ಬರಮಾಡಿಕೊಳ್ತಾ ಇದ್ದಾರೆ.
ಇದೀಗ ಕಾರ್ಯಕ್ರಮದ ಶುಭಾರಂಭ ರಾಷ್ಟ್ರಕವಿ ಕುವೆಂಪು ವಿರಚಿತ ನಾಡಗೀತೆಯೊಂದಿಗೆ ಎಲ್ಲ ಗಣ್ಯರು ದಯಮಾಡಿ ಎದ್ದು ನಿಂತು ಗೌರವವನ್ನು ಸೂಚಿಸಬೇಕು ಅಂತ ಕೋರ್ಕೊಳ್ತಾ ಇದ್ದೇನೆ.
ನಾಡಗೀತೆ, ದಿ ಸ್ಟೇಟ್ ಆಂಥಮ್ ವಿಲ್ ಬಿ sung now. Shri Prajwal, Kumari Vaishnavi, Kumari Shashwati will sing the ನಾಡಗೀತೆ.
जय भारत जननीय तनुजाते, जय हे कर्नाटक माते, जय सुंदर नदी वनಗಳ ನಾಡೆ, जय हे रस ಋಷಿಗಳ ಬೀಡೆ, ಭೂದೇವಿಯ ಮಕುಟದ ನವಮಣಿಯೇ, ಗಂಧದ ಚಂದದ ಹೊನ್ನಿನ ಗಣಿಯೇ, ರಾಘವ ಮಧುಸೂದನರವತರಿಸಿದ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ, ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ. ಜನನಿಯ ಜೋಗುಳ ವೇದದ ಘೋಷ, ಜನನಿಗೆ ಜೀವವು ನಿನ್ನಾವೇಶ, ಹಸುರಿನ ಗಿರಿಗಳ ಸಾಲೆ, ನಿನ್ನಯ ಕೊರಳಿನ ಮಾಲೆ, ಕಪಿಲ ಪತಂಜಲ ಗೌತಮ ಜಿನನುತ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ, ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ. ಶಂಕರ ರಮನುಜ ವಿದ್ಯಾರಣ್ಯ, ಬಸವೇಶ್ವರ ಮಧ್ವರ ದಿವ್ಯಾರಣ್ಯ, ನನ್ನ ಷಡಕ್ಷರಿ ಪೊನ್ನ, ಪಂಪಲ ಕುಮಿಪತಿ ಜನ್ನ, ಕುಮಾರ ವ್ಯಾಸರ ಮಂಗಳಧಾಮ, ಕವಿ ಕೋಗಿಲೆಗಳ ಪುಣ್ಯಾರಾಮ, ನಾನಕ ರಾಮಾನಂದ ಕಬೀರರ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ, ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ. ತೈಲಪ ಹೊಯ್ಸಳರಾಳಿದ ನಾಡೆ, ಕಂಕಣ ಜಕಣರ ನೆಚ್ಚಿನ ಬೀಡೆ, ಕೃಷ್ಣ ಶರಾವತಿ ತುಂಗ, ಕಾವೇರಿಯವರ ರಂಗ, ಚೈತನ್ಯ ಪರಮಹಂಸ ವಿವೇಕರ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ, ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ. ಸರ್ವ ಜನಾಂಗದ ಶಾಂತಿಯ ತೋಟ, ರಸಿಕರ ಕಂಗಳ ಸೆಳೆಯುವ ನೋಟ, ಹಿಂದೂ ಕ್ರೈಸ್ತ ಮುಸಲ್ಮಾನ, ಪಾರಸಿಕ ಜೈನರುದ್ಯಾನ, ಜನಕನ ಓದುವ ದೊರೆಗಳ ಧಾಮ, ಗಾಯಕ ವೈಣಿಕರ ರಾಮ, ಕನ್ನಡ ನುಡಿ ಕುಣಿದಾಡುವ ಗೇಹ, ಕನ್ನಡ ತಾಯಿಯ ಮಕ್ಕಳ ದೇಹ, ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ, ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ, ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ, ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ.
ನಾಡಗೀತೆಗೆ ದನಿಯಾದಂತಹ ಪ್ರಜ್ವಲ್, ವೈಷ್ಣವಿ ಹಾಗೂ ಶಾಶ್ವತಿ ಇವರಿಗೆ ಧನ್ಯವಾದಗಳು. ಆತ್ಮೀಯರೇ, ನ್ಯಾಯದೇವತೆಯ ಅಂಗಳದಲ್ಲಿ ಎಲ್ಲರೂ ಸಮಾನರೇ, ಅಲ್ಲಿ ಬಡವ ಬಲ್ಲಿದರೆಂಬ ಭೇದವಿಲ್ಲ, ಆಳ್ತನ ಸಿರಿತನದ ಹಂಗುಗಳಿಲ್ಲ, ಅಲ್ಲಿರುವುದು ಒಂದೇ, ಅಪರಾಧಿ ಅಥವಾ ನಿರಪರಾಧಿ. ಹೀಗೆ ಭಾರತ ದೇಶವನ್ನ, ಅದರ ಕಾನೂನುಗಳನ್ನ ಸಾರ್ವಕಾಲಿಕವಾಗಿ ಎತ್ತಿ ಹಿಡಿಯುತ್ತಾ ತನ್ಮೂಲಕ ದೇಶವನ್ನ ಸದಾ ಎಚ್ಚರಿರುವ ಪ್ರಜ್ಞಾಸ್ಥಿತಿಯಲ್ಲಿಟ್ಟಿದೆ ಭಾರತದ ನ್ಯಾಯಾಂಗ. ಅದರ ಒಂದು ಭಾಗವಾಗಿ ದಕ್ಷತೆಯಿಂದ ಕಾರ್ಯನಿರ್ವಹಿಸಿಕೊಂಡು ಬಂದಿದೆ ಕರ್ನಾಟಕದ ನ್ಯಾಯಾಂಗ. ಈ ನಿಟ್ಟಿನಲ್ಲಿ ಕರ್ನಾಟಕ ರಾಜ್ಯ ನ್ಯಾಯಾಂಗ ಅಧಿಕಾರಿಗಳ ಸಂಘ ಆಯೋಜಿಸಿರುವ 19ನೇ ರಾಜ್ಯ ಮಟ್ಟದ ದ್ವೈವಾರ್ಷಿಕ ಸಮ್ಮೇಳನಕ್ಕೆ ತಮಗೆಲ್ಲ ಕಾರ್ಯಕ್ರಮದ ನಿರೂಪಕರಾಗಿ ನಾನು ವೀಣಾ ಶರ್ಮಾ,
ನಾನು ಬಾಲು
ಆದರದ ಸ್ವಾಗತವನ್ನ ಕೋರ್ತಾ ಇದ್ದೇವೆ.
Good afternoon. A warm and hearty welcome to all of you to this 19th Biennial conference organized by the Karnataka State Judicial Officers Association in Karnataka. We would like to begin this inaugural session with an inspirational quote of Martin Luther King Jr., who said, "The arc of the moral universe is long, but it bends toward justice." If we observe the focal theme of this conference, judicial process re-engineering and the judicial skill building and other sub-themes of the deliberations, they only echo the spirit of those great words, both in intent and a strong will to practice. With this positive note, may we welcome Sri Mallikarjun Gaud, President, Karnataka State Judicial Officers Association, for his welcome address.
My Lord, Sri Justice Sharad Arvind Bobde, Chief Justice of India, Sri B.S. Yediyurappa, Honorable Chief Minister of Karnataka, my Lords, Honorable Sri Justice Mohan M. Shantanu-Gaudar, Honorable Sri Justice S. Abdul Nazir, Honorable Sri Justice A.S. Bopanna, Judges of the Supreme Court of India, my Lord, Honorable Sri Justice Abhay Srinivas Oak, Chief Justice of Honorable High Court of Karnataka, Honorable Judges of High Court of Karnataka, Honorable former Judges of Supreme Court of India and our High Court, distinguished guests and invitees. It is a historic occasion of monumentous significance that 19th Biennial State Level Conference of Judicial Officers is being held in the hallowed premise of Dr. BABU Rajendra Prasad International Convention Center, GKVK, Bengaluru. It is marvelous to feel real profundity of the fact that great Caesars of law have constellated to grace the function which is being inaugurated by the Honorable Sri Justice Sharad Arvind Bobde, the Chief of the highest court of the largest democracy in the world. His Lordship has been kind enough to be here to bless our association. Our association came into existence on 26th October 1974 by subscribing a memorandum of association. Currently, it has a strength of 1,094. Our association has been insensitive in the pursuit of judicial excellency and well-being of its members. I am happy to announce that our association, under the benign guidance of Honorable Chief Justice Sri Abhay Srinivas Oak, is preparing to adopt a comprehensive health scheme for the judicial officers on the modality of similar scheme already adopted by Maharashtra State Judicial Officers Association. Our association has been holding biennial state level conference of the judicial officers for intellectual advancement of members of the association. First ever conference was held in the year 1980 at Belgaum, and 18 biennial conferences have been held in Bangalore and other parts of the state till date. The 19th Biennial State Level Conference of Judicial Officers is being held in this city, Silicon Valley of India, and the business session has spread over this day and tomorrow. The theme of the conference is Judicial Process Re-engineering and Judicial Skill Building. The 2 days conference focus upon academic sessions such as impact of judicial system on economic performance, talk on personality development and capacity building, emerging technology trends, transformation of judicial system, in-house discussion, challenges and remedies in a day-to-day judicial governance. This conference intends to make endeavor to craft progressive change in the approach to deliver qualitative, responsive and timely justice, and it has intended to aim and achieve a paradigm shift from old conservative thinking to a new, all-inclusive, reformist, pragmatic, techno-savvy judicial system. Access to justice as a fundamental element such as identification and recognition of grievance, awareness and legal advice or assistance, accessibility to court or claim for relief, adjudication of grievance, enforcement of relief, which is of course the ultimate goal of litigant public. Having regard to these fundamental elements and change in the socio-economic status of the citizens, and in order to inspire confidence in the minds of public in general and litigant in particular, a session has been devoted to the subject impact of the judicial system on economic performance. The conference also lays emphasis on the enhancement of the managerial skill of the judicial officers, empowerment of the powers and motivation by way of recommitment of the cause, use of technology for effective management and setting a goal to be achieved. This will definitely result in reaching out to a common man who by choice or act of destiny is approaching before the court. The e-courts project is being implemented in all the courts in the state as a part of ICT-enabled court management. Another session is devoted to the subject emerging technology trends, transformation of judicial system. The judiciary in India has always taken a pragmatic approach in dispensation of justice to the people of this country. Change is always a catalyst for increased efficiency and achievement. It is a welcome sign that Karnataka judiciary is thinking on this. This will change image of the judiciary as a people-friendly institution of the democratic setup, hence the proposed conference. When the office bearers and executive committee members requested His Lordship Honorable Sri Justice Sharad Arvind Bobde, Honorable Chief Justice of India, His Lordship was kind enough to accept our invitation to inaugurate this function. We are privileged to have the kind and gracious presence of His Lordship at the inaugural session. We extend a very warm welcome to His Lordship. When we met Honorable Chief Minister Sri B.S. Yediyurappa with a request to preside over this function, he wholeheartedly accepted our invitation and further asked us to submit our representation regarding our legitimate grievance. It shows his profound concern towards welfare of the members of our association. I welcome him cordially. My Lords, Honorable Sri Justice Mohan M. Shantanu Gaudar, Honorable Sri Justice S. Abdul Nazir and Honorable Sri Justice A.S. Bopana, Judges of Apex Court, especially belongs to us. They spread light and joy wherever they go. When we requested their Lordships to grace this occasion, they were kind enough to accept our invitation. I extend a warm and affectionate welcome to their Lordships. Honorable Chief Justice Sri Abhay Srinivas Oak is a source of inspiration, guide to action and reliable compass for determining the strategy and tactics in our march forward. Our association has organized this conference under his benign guidance. Karnataka State Judicial Officers Medical Welfare Fund scheme, based on the model of Maharashtra State Judicial Officers Medical Welfare Scheme, is a splendid gift of our father figure, Honorable Chief Justice, to our association. I extend warm welcome to cordially welcome my Lord. The gracious presence of Honorable Judges of Honorable High Court has added a significant and value to this conference. I welcome their Lordships. The former judges of our Honorable Supreme Court and High Court have been kind enough to respond to our invitation. I extend warm welcome to them all. I welcome the Chairman and members of Karnataka State Bar Council, Advocate General Sri Prabhuling K. Navodigi, Additional Advocate General State Public Prosecutor Sri V.S. Shilwan, President of the Bengaluru Advocates Board Association Sri A.P. Ranganath and his office bearers, the President of Federation of Women Lawyers, resource persons and all the invitees and the members of our association. I also extend warm welcome to the representatives of print and electronic media and all the staff. I extend a warm welcome to the Chancellor, Registrar of University of Agriculture and Science, State Officer of GKVK. I welcome one and all. Thank you. Jai Hind, Jai Karnataka Mata.
ಆಗಮಿಸಿರುವ ಅತಿಥಿ ಗಣ್ಯರನ್ನ ನೆರೆದಿರುವ ಸಭಾಸದರನ್ನ ಆತ್ಮೀಯವಾಗಿ ಸ್ವಾಗತಿಸಿದಂತಹ ಶ್ರೀಯುತ ಮಲ್ಲಿಕಾರ್ಜುನ್ ಗೌಡ್ ಅವರಿಗೆ ಹೃತ್ಪೂರ್ವಕ ಧನ್ಯವಾದಗಳು.
Now, floral welcome and felicitation to the dignitaries on the dais. First, to Honorable Chief Justice of India, Honorable Sri Justice Sharad Arvind Bobde. Sir will be felicitated by President Karnataka State Judicial Officers Association, Sri Mallikarjun Gaud, and General Secretary, Sri A. Somshekhar, and Registrar General, Sri Badamkar. ಸಾಂಪ್ರದಾಯಿಕವಾದ ಮೈಸೂರು ಪೇಟದ ಸನ್ಮಾನದೊಂದಿಗೆ ಆನರಬಲ್ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಆಫ್ ಇಂಡಿಯಾ ಅವರಿಗೆ ಈಗ ಸನ್ಮಾನ ನಡೀತಾ ಇದೆ. ಕರ್ನಾಟಕದ ಹೆಮ್ಮೆಯ ದಂತದ ಕಲಾಕೃತಿಯೊಂದಿಗೆ
ಒಂದು ಸನ್ಮಾನವನ್ನು ಸ್ವೀಕರಿಸಲು ಕರ್ನಾಟಕ ರಾಜ್ಯದ ಸನ್ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳಾದ ಶ್ರೀಯುತ ಬಿ.ಎಸ್. ಯಡಿಯೂರಪ್ಪ ಅವರಲ್ಲಿ ಕೋರಿಕೊಳ್ತಾ ಇದ್ದೇವೆ. ನ್ಯಾಯಾಂಗಕ್ಕೆ ಗೌರವ ತೋರುವಂತಹ ಒಂದು ಉತ್ಕೃಷ್ಟವಾದ ನಡತೆಯನ್ನು ನಮ್ಮ ಸನ್ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳು ಇದೀಗ ತೋರಿದ್ದಾರೆ. ಅವರನ್ನು ಗೌರವಿಸಲು ಶ್ರೀಯುತ ಶಿವಶಂಕರ ಮರಣನವರ್, ಶ್ರೀಯುತ ಸತೀಶ್ ಸಿಂಗ್ ಹಾಗೂ ಕೆಎಸ್ಜೆಒಎನ ಉಪಾಧ್ಯಕ್ಷರಾದಂತಹ ಷಡಾಕ್ಷರಿ ಪಂಚಾಕ್ಷರಿ ಹಾಗೂ ಕೆಎಸ್ಜೆಒಎನ ಟ್ರೆಷರರ್ ಆದಂತಹ ಶ್ರೀಯುತ ರಾಜು.
Now, Honorable Sri Justice Mohan M. Shantanagowda, sir will be felicitated by Srimati Uma M.G., Sri Srishananda, Executive Member Sri C. Rajashekhar, and Joint Secretary KSJOA Sri Ashok.
Honorable Shri Justice S. Abdul Nazir will be felicitated by Shri Hanchate Sanjeev Kumar, Srimati Mahalakshmi Nirle, and EC member Shri Ram Vasudev, and EC member Shri Dinesh.
And now, felicitation to Honorable Shri Justice A.S. Bopanna. He'll be felicitated by Shri P.N. Desai, Shri Buddhivanta Gowda Veeranna Gowda Patil, members of the Executive Committee, Shri Santosh and Shri Amol.
May I now request Honorable Shri Justice Abhay Srinivas Vok, Chief Justice High Court of Karnataka, to kindly accept our felicitation. I request Srimati Khazi Jaibunisa, Shri Vastramat, Srimati Rupa Kulkarni, and Shri Nagaraj to kindly felicitate Honorable Shri Justice Abhay Srinivas Voka. ಸನ್ಮಾನವಂತಹ ಎಲ್ಲ ಗಣ್ಯರಿಗೂ ಸಹ ನಮ್ಮ ಹೃತ್ಪೂರ್ವಕ ಧನ್ಯವಾದಗಳು. ಆತ್ಮೀಯರೇ, ಅಸತೋ ಮಾ ಸದ್ಗಮಯ ತಮಸೋ ಮಾ ಜ್ಯೋತಿರ್ಗಮಯ. From darkness to light is the wish of seeking Indians from time immemorial. Karnataka State Judicial Officers Association hopes that there will always be a kindly leading light shining to show us the right path. May I now request Honorable Shri Justice Sharad Arvind Bobde, Chief Justice of India, to kindly inaugurate the conference by lighting the lamp. I also request the dignitaries and the dais to kindly join him.
ಈಗ ಈ 19ನೇ ಸಮಾವೇಶದ ಉದ್ಘಾಟನೆ ದೀಪ ಬೆಳಗುವುದರ ಮೂಲಕ ಉದ್ಘಾಟನೆ. ಆನರಬಲ್ ಶ್ರೀ ಜಸ್ಟಿಸ್ ಶರದ್ ಅರವಿಂದ್ ಬೋಬ್ಡೆ ಅವರು, ಚೀಫ್ ಜಸ್ಟಿಸ್ ಆಫ್ ಇಂಡಿಯಾ, ಅವರು ದೀಪ ಬೆಳಗಿಸಿ ಈ 19ನೇ ಸಮಾವೇಶವನ್ನು ಉದ್ಘಾಟಿಸ್ತಾ ಇದ್ದಾರೆ. ಅವರೊಂದಿಗೆ ಇನ್ನಿತರ ಆನರಬಲ್ ಜಸ್ಟಿಸಸ್ ಮತ್ತು ಕರ್ನಾಟಕ ರಾಜ್ಯದ ಮುಖ್ಯಮಂತ್ರಿಗಳು ಶ್ರೀ ಬಿ.ಎಸ್. ಯಡಿಯೂರಪ್ಪ ಅವರು ಕೂಡ ದೀಪವನ್ನು ಬೆಳಗಿಸುವುದರಲ್ಲಿ
ಸತ್ಯದ ಸತ್ವದ ಪಥದಲ್ಲಿ ನ್ಯಾಯವನ್ನು ಕೊಂಡೊಯ್ಯತಕ್ಕಂತಹ ದೀಪವೊಂದು ಜ್ಯೋತಿಯೊಂದು ನಮ್ಮ ನಿಮ್ಮ ನಡುವೆ ಸದಾ ಬೆಳಗುತ್ತಿರಲಿ ಎಂಬ ಸದಾಶಯದಿಂದ ಇದೀಗ ಜ್ಯೋತಿ ಬೆಳಗುವುದರ ಮುಖೇನ ಕಾರ್ಯಕ್ರಮದ ವಿದ್ಯುಕ್ತ ಉದ್ಘಾಟನೆ.
And now, on this momentous occasion, Karnataka State Judicial Officers Medical Welfare Fund is also being launched. It will be launched by Honorable Sri Justice Sharad Arvind Bobde, Honorable Sri Chief Justice of India. Sir will be releasing documents related to this Medical Welfare Fund scheme.
A book as well as a registration certificate is being released by Honorable Sri Justice Sharad Arvind Bobde. ಮೆಡಿಕಲ್ ಸ್ಕೀಮ್ ಅನ್ನು ಲೋಕಾರ್ಪಣೆಗೊಳಿಸಿದಂತಹ ಎಲ್ಲ ಗಣ್ಯರಿಗೂ ಸಹ ಧನ್ಯವಾದಗಳು. Ladies and gentlemen, Benjamin Disraeli once said, "Justice is truth in action." As Chief Justice of High Court of Karnataka, Honorable Chief Justice Abhay Srinivas Oak is in the forefront of that action. May I respectfully invite Honorable Chief Justice to kindly deliver the presidential address.
Honorable Chief Justice of India, Justice Sharad Arvind Bobde, Honorable Chief Minister of Karnataka State, Honorable Sri Justice Mohan N. Chantanagaudar, Honorable Judge of the Supreme Court of India, Honorable Sri Justice Abdul Nazir, Judge Supreme Court of India, Honorable Sri Justice A.S. Bopanna, Judge Supreme Court of India, my esteemed brother and sister judges, past and present, who are present in large numbers, the learned Advocate General, Additional Advocate General, President of the Bangalore Bar Association, other office bearers, large number of senior retired judicial officers who are present here, the learned registrars of the High Court, and senior and distinguished members of the Karnataka Judiciary, learned members of the Karnataka Judicial Officers Association, and ladies and gentlemen. It is a historic occasion for the judicial officers in state and for Karnataka Judicial Officers Association. We are really fortunate that this conference is graced by presence of Honorable the Chief Justice of India, Honorable Chief Minister, and 3 honorable judges of the Apex Court. I don't think in any other earlier conference the judicial officers had benefit of such august presence. We must thank the government of Karnataka for extending huge amount by way of grant, and only that grant made the Judicial Officers Association to hold this function in this venue having international standards. The President has already discussed the topics selected for discussion. They are not only useful but very interesting. The resource persons are experts in their fields. There is going to be a session on stress management. If your President permits, I am tempted to attend that session, because that is bound to be very interesting. Now, with this kind of setup, this kind of a grand conference, my appeal to all the judicial officers who have come here from different corners of the state, not to miss even a single minute of this 2 days conference, because this is a unique opportunity for all of you. Apart from not missing a single minute of the session, what is more important is all the judicial officers must take active part. In fact, tomorrow is the session presided over by me, and I am ready to face questions, not only from about 100 or 200 judicial officers. Even if all of you ask me questions, I'll most welcome them. So I am very keen on all the judicial officers participating wholeheartedly in this conference. The judicial officers in Karnataka are rendering valuable services to the administration of justice. But what we have achieved is not sufficient. Barring handful of districts, I can say that we have better judicial infrastructure than most of the states in India. My endeavor is going to be not to rest with better infrastructure, but to provide the best infrastructure, best judicial infrastructure to our district and trial courts. The state government has been very cooperative when it comes to extending hand for providing infrastructure. Even our Chief Minister and other senior government officials who are present in the court, they know that our demand for allotment of lands and funds will continue. In fact, government will be flooded with such demands unless we are able to give. So long as we don't give best infrastructure to the state, we'll continue to be making demands to the state government, and I'm sure that the existing cooperation will continue. My Lord the Chief Justice, I want to share something with you. We are always told that Saket Court in Delhi is the best court. I don't dispute that. But we are not far behind. Our Taluk Court in Hubli is of international standards, having most dynamic facilities. I am sure that with the help of Honorable Chief Justice Mohan Shantanu Gowda, will be able to persuade Chief Justice to visit Hubli someday. I must tell the judicial officers that when we have such good judicial infrastructure, the expectations of litigants from judicial officers are very high. And as you know, our target is to ensure that no district or trial court should have a single 5-year-old case pending on 31st of December 2020. So in that way, our target is to see that state of Karnataka is arrears-free state by end of the year 2020. I seek cooperation from all the members of the judiciary to achieve this target. Achieve this target is not going to be easy. We'll require change of approach. We need to innovate. We need to adopt more and more techniques. I have been working with the office bearers of the association. There were a large number of demands put forward. I'll just refer to the major demands. One major demand regarding pension to judicial officers is being taken care on the judicial side, so I'll not refer to that. The other one and most important one was regarding grant of superintendent scale to eligible senior district judges and selection grade. As far as super time scale is concerned, I don't think we have any, there is any applicant, any judicial officers who comes into zone of consideration. As far as selection grade is concerned, we are required to correct our procedure because earlier we are not considering the cases on merits. Therefore, now all the files are ready. We have called for the judgments, they are ready. And in every week, administrative committee will consider 10 to 20 cases. And I hope to see that by end of April, that process will be complete. There was another outstanding demand for grant of assured career progression, ACP benefit. Even those files are ready. Committee is considering all the files. There was other issue of grant of advance increment to those judicial officers who are holding LLM degree. So 76 officers whose marks have been verified by the concerned universities have already conferred the benefit. We are awaiting verification from the universities in case of remaining about 80 candidates. These are briefly the points raised by the Judicial Officers Association. Other points will be dealt with tomorrow in my own session. There is one more decision which I had taken yesterday by making an appeal. Notwithstanding what is said in at least 2 Law Commission reports, what was said in the Shetty Commission recommendations, we still continue to use terms like lower court and subordinate court. So I issued an appeal that neither on the judicial side nor on the administrative side, we should be referring to any court as subordinate court or lower court, because no court is inferior. There is no difference between the role played by judges of the High Court and judges of the trial courts and district courts. So I issued an appeal yesterday, which will reach all of you within a day or two, that whenever we refer to the courts which are under the superintendence of High Court, we should refer them as district courts and trial courts. In fact, in so many judgments of the judicial officers, district judges and civil judges, senior judges, I have noticed that in appeal judgment they repeatedly refer to lower court, subordinate court. So I have made appeal to them that at least for the state, as far as state of Karnataka is concerned, all judges who are working in district and taluk courts will be treated with respect. Mere discussion on our achievements and accomplishments will not be sufficient. We have to aim for greater glory, and this conference should become a source of inspiration for that. After independence, we kept on saying that common man of this country has a great faith in judiciary. But we never made introspection on this aspect to ascertain whether that faith still subsists after so many years after the independence. The Apex Court has repeatedly said, and we also say on the administrative side, that it is the duty of the state to provide all necessary funds to provide best infrastructure to institution of judiciary. But when judiciary receives large funds from the government, ultimately those funds constitute public money. Therefore, as judicial officers, as members of the institution of judiciary, we become accountable to the citizens of this country. And therefore, a conference like this should be used to make introspection on the issue of accountability. If the litigants have lost faith to some extent in an institution, how to regain the faith? Because ultimately, our aim should be to provide quality justice. Only if we provide quality justice, then we can say that we have understood that we are accountable to common man of this country, because we survive on public funds. Even all these aspects need to be considered in a conference like this, or maybe in future conference, as this is the time to make introspection, this is the time to make collective thinking and find out good solutions to our problems. I thank the organizers of this function for giving me this opportunity to preside over this function and to say a few words. I wish a great success to this conference. I wish a great success to all the judicial officers who have come here and who are participating in this conference. I thank all of you. Thank you very much.
On behalf of KSJU and everyone present here, I thank Honorable Chief Justice Abhay Srinivaswu, Chief Justice High Court of Karnataka, for delivering the presidential letter. Thank you, sir.
We now request Honorable Chief Justice A.S. Bopanna, Judge, Supreme Court of India, to kindly address the gathering.
Honorable Shri Justice Sharad Arvind Bobde, Chief Justice of India, Honorable Justice Mohan Shantangowdar, Judge, Supreme Court of India, Honorable Justice S. Abdul Nazir, Judge, Supreme Court of India, Honorable Justice Abhay Srinivas Hoke, Chief Justice High Court of Karnataka, Shri B.S. Yediyurappa, Honorable Chief Minister, Government of Karnataka, Shri Mallikarjun Gaud, President of the Association, Somshekhar, Secretary of the Association, my colleague judges, both past and present in the High Court of Karnataka, former Chief Justices, Lokayukta, Advocates Association President and members, Advocate General, Additional Advocate General, Additional Solicitor General, Assistant Solicitor General, and my dear judicial officers. In fact, I was taken by surprise that I had to speak earlier, as otherwise I would have probably adopted whatever the learned senior judges had said about in an occasion of this nature. The conference of the judicial officers, it is the 19th Biennial State Level Conference. Of course, in that view, the conference in any event would take place once in 2 years. However, what impresses me is the subject that is chosen as the theme for the conference. That's the judicial process re-engineering and judicial skill building. Judicial process re-engineering would mean readjustment of the resources for the purpose of the proper functioning of the judiciary, which may include the procedural aspects, the infrastructure, and the way the judiciary is to function. I don't know whether it is a coincidence or whether it is by design. The day has started today in that direction. In fact, the new building of the Judicial Academy was inaugurated by Honorable the Chief Justice of India this morning. Probably the judicial process re-engineering has started from there, inasmuch as the judicial education and the refresher courses would render some assistance in this regard and would help the judiciary to function in an appropriate manner. In fact, when we saw the building and we were mentioning that it is of 7-star quality, the President of the Judicial Academy was mentioning not only the building is 7-star quality, the training also would be 7-star quality. So let us all hope that it would be implemented and the same would function like this. Now when we talk of judicial process re-engineering, the concept is initially to see that the things are improved and the process of rendering justice is speeded up. In fact, the other day I was just watching a video where one of the speakers in a TEDx forum, one Mr. Kishore, was talking about the process of judiciary and the delay in disposal of the cases. With specific reference to certain cases, he had mentioned the time that would take in disposal of a case, and in fact in some of these states, of course he mentioned, and let me not mention all those aspects here, but the fact that some of the disposal of the criminal cases would take that long, of 7 to 9 years, some would remain as under trials for that long, which is not good for the system. And of course, he being a technology expert, he was only talking about the way the computerization could take place and the manner in which it could proceed. And while addressing his audience, who were all technology experts, he was mentioning about the quantity of justice. In fact, he made a specific mention that they are more concerned about the quantity of justice, and the quality he is not concerned, because there are other people who can worry about those things, because he was only saying about the technology that could be adopted and the more number of cases that could be disposed of. But the Chief Justice of Karnataka High Court in his speech mentioned about the quality of justice. Probably a conference like this would help in discussing ways and means, not only for the quantity but the quality of justice, and keeping in view the nature of the subjects that have been kept for discussion in the two days. I am sure the deliberations would be to that effect, and at the end of it, there would be a lot of deliberation which would result in all the officers also putting forth their suggestions of ways and means where the process of re-engineering can take place, and the quality of justice, as also the time gap between the filing and the disposal is reduced. I thank the organizers for giving me this opportunity, being a part of this conference, and I thank you very much.
We sincerely thank Honorable Free Justice A.S. Bopanna for his insightful address.
ಆತ್ಮೀಯರೇ, ಕನಸೊಂದ ಕಾಣುವುದಕ್ಕೆ ಮನಸ್ಸು ಬೇಕು. ಆ ಕನಸನ್ನು ನನಸಾಗಿಸಲು ಹುಮ್ಮಸ್ಸು ಬೇಕು. ಕನಸು, ನನಸು ಮತ್ತು ಹುಮ್ಮಸ್ಸುಗಳು ಇಷ್ಟೇ ಇದ್ದರೆ ಸಾಲದು, ಗುರಿಯತ್ತ ಸಾಗುವ ದೃಢ ಸಂಕಲ್ಪವಿರಬೇಕು. ಆ ಸಂಕಲ್ಪಕ್ಕೆ ಸಮಯಾಧಾರಿತ ಕಾರ್ಯಸೂಚಿ ಸಹ ಬೇಕು. ಇವೆಲ್ಲವನ್ನ ನಮಗೆ ಒದಗಿಸಿಕೊಟ್ಟು ನಿರಂತರವಾಗಿ ಪ್ರಗತಿ ಪಥದತ್ತ ಸಾಗಲು ಅನುವು ಮಾಡಿಕೊಡ್ತಾ ಇರ್ತಕ್ಕಂಥವರು ಭಾರತ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಮೂರ್ತಿಗಳಾದಂತಹ ಆನರಬಲ್ ಶ್ರೀ ಜಸ್ಟಿಸ್ ಎಸ್ ಅಬ್ದುಲ್ ನಜೀರ್ ಸರ್. ಇದೀಗ ಅವರ ಅನಿಸಿಕೆಗಳಿಗಾಗಿ ಕೋರಿಕೆ.
Honorable Justice Sharad Arvind Bobde, Chief Justice of India, Honorable Chief Minister of Government of Karnataka, Shri B.S. Yediyurappa, Honorable Justice Mohan M. Shantanagowda and Honorable Justice A.S. Bopanna, Judges of the Supreme Court of India, Honorable Judges of the High Court of Karnataka and former Judges of the High Court of Karnataka, Mr. Justice Vishwanath Shetty, Lokayukta, and Shri S.R. Bannurmat, former Chief Justice of Kerala High Court, Mr. Mallikarjuna Gaud, and Shri Somshekar, President and Secretary of the Karnataka State Judicial Officers Association, Learned Advocate General and Additional Advocate General, Solicitor General and Additional Solicitor General, respected judicial officers, and all my friends. Normally, I am an expert in adopting other speeches, as I used to do as a lawyer, because I used to adopt the arguments of senior advocates and only collect the fees. But today, I want to be a bit different, because I have to address the judicial officers. The framers of the Constitution of India envisaged a unique position for the Indian judiciary. It was to be an arm of social revolution that has conceptualized through the Constitution and aimed at achieving a goal that has been beautifully summarized in the preamble of the Constitution of India: justice, social, economic, political, for all its citizens. Judiciary was to be the guardian of the Constitution and the bastion of rights and of justice. Since this is Judicial Officers Conference, I propose to talk a few things about the duties and responsibilities of the judicial officers. Most of you here are trial judges. Chief Justice Ranganath Mishra in All India Judges Case 92 judgment summed up the role of trial judges, and I quote, "The trial judge is the kingpin in the hierarchical system of administration of justice. He directly comes in contact with the litigant during the proceedings in court. On him lies the responsibility of building up of the case appropriately, and on his understanding of the matter, the cause of justice is first answered. The personalities, knowledge, judicial restraint, capacity to maintain dignity are the additional aspects which go into the making the court's functioning successful." Unquote. Mentioning the high expectation of society from the judges, he further advises, quote, "A judge ought to be wise enough to know that he is fallible and therefore ever ready to learn, and be courageous enough to acknowledge his errors." A judicial officer, especially from subordinate judiciary, sorry, I am using this word subordinate, is the face of judiciary to most litigants. In the words of the Supreme Court, he is the kingpin of the administration of justice. He is the one who directly comes in contact with the litigants during the proceedings in the court. Therefore, his conduct, both professional and personal, is of immense importance. A fundamental responsibility of a judge is not to engage in conduct incompatible with diligent discharge of judicial duties. A good judge is not simply a combination of knowledge, intellect and skills. What makes a good judge is the manner in which the three are brought together to render justice. Here I must refer to the notion of judicial ethics, which involves 5 crucial principles: independence, detachment, integrity, impartiality, and the most important, humility. It is the responsibility of every judicial officer to strictly adhere by them. The first step in settling the disputes involves understanding the disputes in its entirety. Understanding commences with listening to the parties. The complaint is judges don't listen to the parties. Opportunity of being heard is a crucial right, a principle of natural justice, audi alteram partem, all of you know. A common complaint is that the judge hardly hears the matter before rendering a decision. Judges must develop the art of listening, in particular active listening. Active listening necessarily entails adequate preparation in a matter and making effective interventions and interjections to keep the proceedings on course and not unnecessary interjections. Adequate preparation would also allow the judicial officer to effectively check tendency to make long and irrelevant arguments, which not only delay the whole proceedings, but also waste precious time of all involved. It is important to understand that judicial officers not only extend outwards, but in equal measure inwards. He has a duty of what could broadly be termed as self-management. This concept would include self-discipline, commitment, punctuality, dedication, and hard work. These concepts would greatly influence the conduct of the court. Further, good working can only be expected from a healthy individual. Health here focusing on both physical and mental. The work undertaken by judicial officers can be extremely stressful, which we all know can have severe health implications. A healthy mind would enable to perform judicial duties efficiently, fairly, and to the best of their abilities. Judiciary is an integral part of the society and plays a crucial role in its functioning. It is a repository of the faith and confidence of people. It was envisaged as and remains the ultimate guardian of rights and liberties of people. Its very existence to secure one goal, justice for all. It is the duty of judicial officers to work tirelessly to ensure fruition of that goal through efficient, competent, and compassionate working. Let me conclude by reminding all the poignant words of Chief Justice Ranganath Mishra in All India Judges case. I quote, this is very important. The conduct of every judicial officer should be above reproach. He should be conscientious, studious, thorough, courteous, patient, punctual, just, impartial, fearless of public clamor, regardless of public praise, and indifferent to private, political, or partisan influences. He should administer justice according to law and deal with his appointment as a public trust. He should not allow other affairs or his private interests to interfere with the prompt and proper performance of his judicial duties, nor should he administer the office for the purpose of advancing his personal ambitions and increasing his popularity. I think all of us may have to take very seriously this note. With those words, I thank Karnataka State Judicial Officers Association for giving me this opportunity to share my views. I wish the 19th Biennial State Level Conference of Judicial Officer 2020 a great success. Thank you very much.
We sincerely thank Honorable Shri Justice Abdul Nazir, Judge, Supreme Court of India, for his thought-provoking, highlighting the significance of reflecting skills among the judicial officers. Thank you very much, sir.
Ladies and gentlemen, maintaining highest level of standards with respect to judicial system and adopting the Kaizen, continuous improvement path when it comes to formulating a capable, independent and fearless judicial service are the mottos of Karnataka State Judicial Officers Association. On the occasion of its 19th Biennial Conference, may I request Honorable Shri Justice Mohanyam Shantanagowda, Judge Supreme Court of India, to kindly share his thoughts.
Your accent is just like our Attorney General's accent. Your accent is Attorney General's accent. Honorable Justice Sharad Arvind Bobde, the Honorable Chief Justice of India, Shri B.S. Yediyurappa, the Honorable Chief Minister of Karnataka State, my dear friends, my colleagues in the Supreme Court, Justice S. Abdul Nazir Saab and Mrs. Abdul Nazir Saab, Justice S. Bopanna Saab, Chief Justice of High Court of Karnataka, Abhay Srinivas Oak, Honorable Judges of the High Court, past and present, former Chief Justice of Kerala High Court, Justices Arban Nurmat, Lokayukta, Justice P. Vishwanath Shetty, Advocate General Mr. Prabhuling Nawadgi and his team, Additional Solicitor Sri M.B. Nargund and his team, Registrar of High Court of Karnataka and his team, President of the Bar Mr. Ranganath and his team, law students, judicial officers, law students and invitees. Generally I love to speak extempo, but today I do not dare to speak because in the presence of Honorable Chief Justice of India. More particularly, I would have spoken in Kannada language, but since Chief Justice as well as the Chief Justice for Karnataka, both Chief Justices do not know Kannada language, I defer myself in doing so. Dear friends, it gives me great pleasure to be amongst you at this 19th Biennial Conference, State Judicial Officers Conference. It is a great opportunity for you to be able to hear from the experienced and learned speakers about the modern day challenges and experiences faced by the judicial officers. I am happy to observe that the performance of district judiciary in Karnataka has improved over the years. The Karnataka district judiciary has one of the most effective case disposal mechanisms in the country, which is certainly on account of its talented and well-trained judicial officers. However, there is no gain in resting on one's own laurels. With time, it is necessary to introspect and to reinvent our methods of working. Hence, the need must have been felt for organizing this conference on the theme of judicial process re-engineering and judicial skill building. I would also like to share some of the insights which I have gained over the course of the years, and I hope they will prove useful in traversing the various hurdles you face in your work. The recent data shows that 86% of the overall pendency of the cases in the country is before district judiciary. It is the district judiciary which is predominant driving force of adjudication in this country. Litigants face substantial socio-economic barriers in assessing the higher courts and appeal. Thus, only the minuscule fraction of litigation reaches the High Court and the Supreme Court. In many cases, it is the subordinate courts which end up being the courts of last resort for those hailing from disadvantaged backgrounds. Hence, it is you as members of the district judiciary who are best placed to interact with the people and see the reality of dispute resolution in the country. No doubt, the aforesaid may be in the debate is sheer magnitude of human element of the judiciary's operation. Though having an up-to-date knowledge of contemporary legal jurisprudence is of paramount importance, being a judge also requires having an in-depth knowledge of human psyche. We will have to study to a certain extent human psychology also. From civil cases to family court cases, from motor vehicles cases to labor claims, very often the crux of the matter does not involve ascertaining which judgment or citation is applicable, to the facts, but rather understanding what drives parties to approach the court in the first place. It is no use only to study and apply some citations which are already delivered by the High Court or Supreme Court, but ultimately, crux of the matter has to be visited by the judicial officers, particularly having regard to the social setup in which the parties are placed. I would like to share an anecdote. I'll give an example. When I was a chairman of the mediation center in Bangalore, a family court is also situated there. One of my friends was a family court judge. After finishing his work, he came at 5 o'clock or 5:30 and we were having tea. And he was telling an interesting case relating to a child custody. The father had filed documents. The child was living with the father. Mother had claimed custody of the child. The father had produced documents to show that the child is studying in the city in which the husband was living. That is, the father was living. And the child was interviewed by the judge in the chamber repeatedly. But in the interviews or in the interaction with the child said, no, my school is situated in my mother's place. Despite repeated suggestions by the judge, the child stuck to his stand that his school is situated in the place where the mother was living. Actually, the child was telling falsehood. But the concerned judge gave custody to the mother. I asked him, how did you disbelieve? Why did you disbelieve the documents produced by the husband? It is the convenience of the child, etc. He said, I knew that the child was lying, but the child was very well wanting to go along with the mother. The child wanted the custody of the mother. In that sense, having learned the psychology of the child, I granted the custody to the mother. Sometimes you will have to have this type of general knowledge also. So, and you will have to have you will have to be conversant with the particular customs, traditions and practices of the area wherein they are living. It all depends upon the situation of the parents also. Further, being a trial judge, familiarity with the intricacies of both procedural and court's own internal rules and regulations. It is your duty to correct the officers of the court if there is any error by them in following the same. Hence, there is no scope for you to falter. As a judge, there is also an added responsibility of being functionary of the state and not the government. Many times the trial courts are criticized for being mouthpieces of the prosecution in criminal trials. In other cases, the allegations of corruption and procedural lapses are openly made against the courts. It deeply saddens me that the trial courts, which enjoy the maximum exposure to the public and highest volume of litigation, are so easily susceptible to slander. Judges are bound to behave in a non-partisan manner so as to serve the larger constitutional purpose of the judiciary in governance of the polity, as Justice Nazir put it. All these skills and responsibilities cannot be discharged simply through reading the latest editions of case reports or pursuing commentaries. Ordinarily, it is the experience of having served the requisite number of years on the bench or in practice which enable one to gain mastery with court procedure and personality assessment of various parties appearing before the court. However, till the time they acquire such experience, the judicial officers will make their own independent efforts to improve their personality development and capacity building, which is the theme that will be illuminated by learned speakers today. In my address to previous batches of judicial officers, I had spoken about the importance of integrity. In the last judicial officers conference, I had highlighted the Bangalore principles, etc., more relating to integrity. But this time, I want to address on personality development and more particularly the behavioral pattern of the judicial officers, because I have heard so many facts in the practical life. However, maintaining integrity and scrupulousness is the bare minimum expected from the judicial officer. There needs to be emphasis towards holistic personality development. The debate about the district judiciary is always centered on the lack of vacancies, the low population judge ratio, and so on. These may be valid concerns, but it is also important to focus on improvement of communication skills and empathy levels of judicial officers. We are so preoccupied with the problems of recruitment of judges that we do not address the question, what next? Correct training in the appropriate court etiquette, behavior, and morals expected from a judge is necessary to mold their personalities such that they inspire confidence in litigants, advocates, and community at large. It's a matter of great concern that lately reports have come of altercations and unpleasant exchanges between the judicial officers and members of the bar as well as the litigants. This does not behove an officer of the court to squabble with advocates, particularly senior members of the bar in court. Merely because one has the privilege of sitting on the raised dais, it does not mean that they are at liberty to disrespect those who have been serving the court longer than the age of a judge. As we as judges should always remember that no matter how the post of a person occupies, the law is above him. This adage applies to judges as well. Of course, I do not wish to attribute complete blame only on the judges. Perhaps the adversarial atmosphere in the court is such that it forces judges along with the disputing advocates into isolated spheres. Since they are overworked, overwhelmed with the pendency of cases and catena of simultaneous administrative responsibilities, it is natural for them to feel frustrated and want to deflect that anger elsewhere. However, this does not mean that the court should adopt a confrontational attitude towards arguing counsel. The atmosphere should be one of collaboration and not of conflict. Having spent so many years at the bar, it is the senior advocates who may be best placed to guide the court and help reach the equitable outcome. Instead of speaking in an aggressive or patronizing tone towards the advocates, the court should instead focus on asking them the right questions so that they can render appropriate assistance to the court. This would also help identify those who are trying to mislead the court and have no real intention of helping adjudication of the case. Further, if we as judges display a dignified attitude towards the counsels, their respect for us increases. The higher the advocate's respect for the bench, the more the likelihood that they would be incentivized to honestly assist us as officers of the court instead of resorting to self-serving and unscrupulous methods. Once atmosphere of mutual collaboration is created, the web of pendency will automatically untangle itself. Hence, it is necessary for all the judges, more particularly the newly appointed judges, to cultivate maturity, patience, humility, and empathy in their approach towards those who come before them, be it a most high-profile advocate or the most vulnerable litigant. The administrative staff and the maintenance of infrastructure within the court are integral to efficient case management. Neglecting them contributes to increasing the problem of judicial backlog. As members of district judiciary, it is your responsibility to interact with the staff, ascertain their concerns, push their reforms for improving their working conditions. One way of solving the current problems is by focusing on technological solutions. I am happy to observe that the Karnataka courts are performing well on indicators of computerization delivery services, and the judicial officers have high level of computer literacy. I commend the said aspect. The e-courts mission mode project is being successfully implemented in Karnataka. I hope that the positive performance continues and the judicial officers acquire further training in technological case management solutions. A better IT infrastructure support system would go a long way in helping the same. I am sure you all will learn about the ways to tackle the aforementioned issues in great details over the course of this conference. I may take this opportunity to highlight that Honorable Justice S.A. Bobde, the Honorable Chief Justice of India, will also be addressing you all at the conference today. It would serve all of us well to pay particular heed to his words as Justice Bobde personifies. the qualities necessary for the judicial officer to imbibe, which I have attempted to elucidate in my address today. Indeed, he is warm-hearted and compassionate. Furthermore, not only is he erudite and discerning in the law, but is also always receptive to queries from those seeking to expand horizons of their knowledge, no matter how abstruse the subject. I have had the privilege of benefiting from his counsel for the purpose of tackling professional and personal challenges. To conclude, friends, the overall point which I have attempted to stress on today is that as judicial officers, there is a need for you to think out of box. You should not restrict yourself to fulfilling the conventional expectations of your roles and responsibilities. The existing negative stereotypes about the district judiciary should not be taken for granted, especially given that you have been doing such an excellent job so far. Preparation and training for serving in the post of judge is a continuous process. Acquiring principles of human resource management has become as important as acquiring knowledge of the latest landmark judgments. Hence, you should be striving to improve all aspects of your personality and not just your legal knowledge. I have no doubt that once this is undertaken, you will excel in your future endeavors. I wish for the successful completion of the conference and wish you all the very best for the new year. Thank you. Jai Hind.
Our sincere thanks to Honorable Free Justice Mohan M. Shantanagowda for his appreciation of the work of the Karnataka judicial officers and also for sharing his insights on different dimensions of skill building, training and out-of-the-box solutions, and also highlighting professional discipline and other issues. Thank you very much, sir.
ಆತ್ಮೀಯರೇ, ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ಚುಕ್ಕಾಣಿಯನ್ನು ಹಿಡಿದು ಅದನ್ನು ಸಮರ್ಥವಾಗಿ ಯಶಸ್ವಿಯಾಗಿ ಮುನ್ನಡೆಸ್ತಾ ಇರ್ತಕ್ಕಂಥವರು ಕರ್ನಾಟಕದ ಸನ್ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳಾದಂತಹ BS ಯಡಿಯೂರಪ್ಪನವರು. ಇದೀಗ ಸನ್ಮಾನ ಮುಖ್ಯಮಂತ್ರಿಗಳಲ್ಲಿ ಅವರ ಅನಿಸಿಕೆಗಳಿಗಾಗಿ ಕೋರಿಕೆ.
ಕರ್ನಾಟಕ ರಾಜ್ಯ ನ್ಯಾಯಾಂಗಾಧಿಕಾರಿಗಳ 19ನೇ ದ್ವೈವಾರ್ಷಿಕ ಸಮ್ಮೇಳನದ ಉದ್ಘಾಟನಾ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಉಪಸ್ಥಿತರಿರುವಂಥ ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ಮುಖ್ಯ ನ್ಯಾಯಾಧೀಶರಾದಂಥ ಗೌರವಾನ್ವಿತ ಶ್ರೀಯುತ ಜಸ್ಟಿಸ್ ಶರದ್ ಅರವಿಂದ್ ಬೋಬಡೆ ಅವರೇ, ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ನ್ಯಾಯಾಧೀಶರುಗಳಾದಂಥ ಶ್ರೀಯುತ ಜಸ್ಟಿಸ್ ಮೋಹನ್ ಶಾಂತನಗೌಡ ಅವರೇ, ಶ್ರೀಯುತ ಜಸ್ಟಿಸ್ ಅಬ್ದುಲ್ ನಜೀರ್ ಅವರೇ, ಶ್ರೀಯುತ ಜಸ್ಟಿಸ್ ಎಸ್ ಬೋಪಣ್ಣ ಅವರೇ, ಮಾನ್ಯ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಗೌರವಾನ್ವಿತ ಮುಖ್ಯ ನ್ಯಾಯಾಧೀಶರಾದಂಥ ಶ್ರೀಯುತ ಜಸ್ಟಿಸ್ ಅಭಯ ಶ್ರೀನಿವಾಸ್ ಓಕ್ ಅವರೇ, ಕರ್ನಾಟಕ ರಾಜ್ಯದ ನ್ಯಾಯಾಂಗ ಅಧಿಕಾರಿಗಳ ಸಂಘದ ಅಧ್ಯಕ್ಷರೇ, ಕಾರ್ಯದರ್ಶಿಯವರೇ, ಸಭಿಕರೇ, ಇಲ್ಲಿ ನೆರೆದಿರುವ ಎಲ್ಲ ನ್ಯಾಯಾಧೀಶಗಳೇ, ನ್ಯಾಯಾಂಗ ಅಧಿಕಾರಿಗಳೇ, ಮಾಧ್ಯಮದ ಸ್ನೇಹಿತರೆ, ಬಂಧುಗಳೇ, ಫಸ್ಟ್ ಆಫ್ ಆಲ್ I extend warm greetings for Shankranti and welcome Honorable Chief Justice of India and all the dignitaries to Karnataka. It is indeed a great pleasure to take part in this biennial state-level conference of judicial officers. ರಾಜ್ಯದ ಸಮಸ್ತ ನ್ಯಾಯಾಧೀಶಗಳು ಸೇರಿ ಈಗ ಚರ್ಚೆ ಮಾಡ್ತಿರುವಂಥ ಆಯ್ಕೆ ಮಾಡಿಕೊಂಡ ವಿಷಯ ಇಂಪ್ಯಾಕ್ಟ್ ಆಫ್ ಜುಡಿಷಿಯಲ್ ಸಿಸ್ಟಮ್ ಎಕನಾಮಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಹಾಗೂ ಎಮರ್ಜಿಂಗ್ ಟೆಕ್ನಾಲಜಿ ಟ್ರೆಂಡ್ಸ್ ದಟ್ ವಿಲ್ ಟ್ರಾನ್ಸ್ಫಾರ್ಮ್ ಎನ್ನುವ ವಿಷಯಗಳ ಅತ್ಯಂತ ಪ್ರಸ್ತುತವಾದಂಥ ವಿಷಯಗಳ ಬಗ್ಗೆ ಚರ್ಚೆ ಆಗ್ತಾ ಇದೆ. ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ, ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ವಿನಿಯಮದಂತೆ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಕಾನೂನು ಸೇವೆಗಳ ಪ್ರಾಧಿಕಾರ ಮಾನ್ಯ ಶ್ರೀಯುತ ಜಸ್ಟಿಸ್ ಅಭಯ ಶ್ರೀನಿವಾಸ್ ಓಕ್ ಅವರ ಆದೇಶದನ್ವಯ ನೆರೆಬಾಧಿತ ಪ್ರದೇಶಗಳಲ್ಲಿ ಸರ್ಕಾರದ ಅಧಿಕಾರಿಗಳ ಜೊತೆಗೆ ಸಂಬಂಧಪಟ್ಟ ಜಿಲ್ಲಾ ಹಾಗೂ ತಾಲೂಕು ಕಾನೂನು ಸೇವೆಗಳ ಪ್ರಾಧಿಕಾರಗಳು ಸಹ ಪರಿಹಾರ ಕಾರ್ಯದಲ್ಲಿ ಭಾಗವಹಿಸಿ ಸರ್ಕಾರದ ಕ್ರಮಗಳಿಗೆ ಕೈಜೋಡಿಸಿರುವುದಕ್ಕೆ ಧನ್ಯವಾದವನ್ನು ಅರ್ಪಿಸುತ್ತೇನೆ. ಕರ್ನಾಟಕ ರಾಜ್ಯದ ನ್ಯಾಯದಾನ ವ್ಯವಸ್ಥೆ ಸುಧಾರಣೆಗೆ ನಮ್ಮ ಸರ್ಕಾರ ಸಂಪೂರ್ಣ ಬೆಂಬಲ ನೀಡ್ತಾ ಇದೆ. ಕರ್ನಾಟಕ ರಾಜ್ಯದಲ್ಲಿ ಅತಿ ಹೆಚ್ಚು ನ್ಯಾಯಾಧೀಶಗಳು ನೇಮಕವಾಗಿದ್ದು, ಇದರಿಂದ ನ್ಯಾಯದಾನ ಪ್ರಕ್ರಿಯೆ ಇನ್ನಷ್ಟು ಚುರುಕುಗೊಳ್ಳಲಿದೆ ಎಂದು ನಾನು ನಂಬಿದ್ದೇನೆ. ಕರ್ನಾಟಕ ರಾಜ್ಯ ನ್ಯಾಯಾಂಗ ಮತ್ತು ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಕಂಪ್ಯೂಟರೀಕರಣದಲ್ಲಿ ದೇಶದಲ್ಲಿಯೇ ಮುಂಚೂಣಿಯಲ್ಲಿದೆ ಅನ್ನೋದು ನಿಮಗೆಲ್ಲ ಗೊತ್ತಿರುವಂಥ ಸಂಗತಿ. ಈ ನಿಟ್ಟಿನಲ್ಲಿ ನ್ಯಾಯಾಂಗ ಇಲಾಖೆ ಕಟ್ಟಳೆಗೆ ಸಿಸಿಟಿವಿ ಕ್ಯಾಮೆರಾ ಅಳವಡಿಕೆ, ಡಿಜಿಟಲ್ ಸೈನೇಜ್ ಬೋರ್ಡ್ ಅಳವಡಿಕೆ ಹಾಗೂ ದಾಖಲೆಗಳ ಗಣಕೀಕರಣಕ್ಕೆ ಒಟ್ಟು 23 ಕೋಟಿ ರು ಮಂಜೂರು ಮಾಡಲಾಗಿದೆ. ಹೆಚ್ಚುತ್ತಿರುವ ಕೌಟುಂಬಿಕ ವ್ಯಾಜ್ಯಗಳನ್ನು ಶೀಘ್ರ ಇತ್ಯರ್ಥಪಡಿಸೋದಕ್ಕೋಸ್ಕರ ಇನ್ನಷ್ಟು ಕೌಟುಂಬಿಕ ನ್ಯಾಯಾಲಯಗಳು ಮತ್ತು ಪೂರಕ ಸೌಲಭ್ಯಗಳನ್ನು ಒದಗಿಸುವ ನಿಟ್ಟಿನಲ್ಲಿ ನಮ್ಮ ಸರ್ಕಾರ ನ್ಯಾಯ ದೇಗುಲದಲ್ಲಿ 120 ಕೋಟಿ ರು ವೆಚ್ಚದಲ್ಲಿ ಬೃಹತ್ ಕಟ್ಟಡ ನಿರ್ಮಿಸಲು ಅನುಮೋದನೆ ನೀಡಿದೆ. ನಮ್ಮ ರಾಜ್ಯದಲ್ಲಿರುವಂತಹ ಕೌಟುಂಬಿಕ ವ್ಯಾಜ್ಯಗಳನ್ನು ಪರಿಗಣಿಸಿ ಬೇರೆ ಬೇರೆ ಜಿಲ್ಲೆಯಲ್ಲಿ ಒಟ್ಟು 17 ಕೌಟುಂಬಿಕ ನ್ಯಾಯಾಲಯಗಳನ್ನು ಮಂಜೂರು ಮಾಡಲಾಗಿದೆ. ಬೆಂಗಳೂರು ಸಿಎಂಎಂ ಕೋರ್ಟ್ ಮೇಲ್ಭಾಗದಲ್ಲಿ 2ನೇ ಹಂತ ಕಾಮಗಾರಿ ಕೈಗೊಳ್ಳಲಿಕ್ಕೆ ನಮ್ಮ ಸರ್ಕಾರ 35 ಕೋಟಿ ಮಂಜೂರು ಮಾಡಲಾಗಿದೆ. ಬೇರೆ ರಾಜ್ಯಗಳಿಗೆ ಹೋಲಿಸಿದರೆ ನಮ್ಮ ಕರ್ನಾಟಕ ನ್ಯಾಯಾಂಗ ಇಲಾಖೆಗೆ ಉತ್ತಮ ಕಟ್ಟಡ ಸೌಕರ್ಯಗಳನ್ನು ಒದಗಿಸಿಕೊಡಲಾಗ್ತಾ ಇದೆ. ಜಗತ್ತಿನಲ್ಲಿ ನಡೆಯುವ ವಾಣಿಜ್ಯ ವ್ಯವಹಾರಗಳನ್ನು ಪರಿಗಣಿಸಿ ಭಾರತ ದೇಶ ವಿಶ್ವ ಬ್ಯಾಂಕಿಂಗ್ ರ್ಯಾಂಕ್ನಲ್ಲಿ 63ನೇ ಸ್ಥಾನ ಪಡೆದಿದೆ. ದೇಶದಲ್ಲಿ ಕರ್ನಾಟಕ 8ನೇ ಸ್ಥಾನ ಪಡೆದಿದೆ. ಬೆಂಗಳೂರು ನಗರದಲ್ಲಿ ದಾಖಲಾದ ವಾಣಿಜ್ಯ ವ್ಯಾಜ್ಯಗಳನ್ನು ಶೀಘ್ರ ಇತ್ಯರ್ಥ ಮಾಡೋದಕ್ಕೋಸ್ಕರ 8 ಕಮರ್ಷಿಯಲ್ ಕೋರ್ಟ್ ಸ್ಥಾಪನೆ ಮಾಡಲು ನಮ್ಮ ಸರ್ಕಾರ ಮಂಜೂರತಿ ನೀಡಿದೆ. ರಾಜ್ಯದಲ್ಲಿ ಹೆಚ್ಚುತ್ತಿರುವ ಪೋಕ್ಸೋ ಪ್ರಕರಣಗಳು ಮತ್ತು ಮಹಿಳೆಯರ ಮೇಲಿನ ಅತ್ಯಾಚಾರದ ಪ್ರಕರಣಗಳನ್ನು ಅವಲೋಕಿಸಿ ಕರ್ನಾಟಕದಲ್ಲಿ 17 ಪೋಕ್ಸೋ ನ್ಯಾಯಾಲಯಗಳನ್ನು, 14 ತ್ವರಿತ ನ್ಯಾಯಾಲಯಗಳನ್ನು, ಅಂದರೆ ಒಟ್ಟು 31 ಜಿಲ್ಲಾ ಹಂತದ ನ್ಯಾಯಾಲಯಗಳನ್ನು ನಮ್ಮ ಸರ್ಕಾರ ಮಂಜೂರು ಮಾಡಿದೆ. ಕರ್ನಾಟಕ ರಾಜ್ಯದಲ್ಲಿ ಈಗ ಸದ್ಯ ಇಂಥ ನ್ಯಾಯಾಲಯ ಪ್ರಾರಂಭ ಮಾಡೋದಕ್ಕೆ 15 ಜಿಲ್ಲೆಗಳಲ್ಲಿ ಕಟ್ಟಡ ಒದಗಿಸಲಾಗಿದೆ. ನ್ಯಾಯಾಂಗ ಇಲಾಖೆಯವರು ಜಾಗ ಗುರುತಿಸಿದ ಕೂಡಲೇ ಹೆಚ್ಚುವರಿ ಕೋರ್ಟ್ ಕಟ್ಟಡ ಕಟ್ಟಲು ಕ್ರಮ ಕೈಗೊಳ್ಳುತ್ತೇನೆ. ನ್ಯಾಯಾಂಗ ಇಲಾಖೆ ಮೇಲೆ ಅಪಾರ ಗೌರವ ಇದೆ. ಹೀಗಾಗಿ ಮಾನ್ಯ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಯಾವುದೇ ಅಗತ್ಯಗಳನ್ನು ನಮ್ಮ ಗಮನಕ್ಕೆ ತಂದರೆ ರಾಜ್ಯ ಸರ್ಕಾರ ಸಕಾಲಕ್ಕೆ ಸೌಲಭ್ಯವನ್ನು ಒದಗಿಸುತ್ತೆ ಅನ್ನೋ ಭರವಸೆಯನ್ನು ಕೊಡ್ತಾ ಇದ್ದೇನೆ. ನ್ಯಾಯಾಂಗ ಅಧಿಕಾರಿಗಳ ಸಂಘ ತಮ್ಮ ಸೇವೆ, ವೇತನ ಮತ್ತು ಇತರ ಮೂಲ ಸೌಕರ್ಯಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕೆಲವು ಬೇಡಿಕೆಗಳನ್ನು ಸಲ್ಲಿಸಿರುವಂಥದ್ದು ನನ್ನ ಗಮನಕ್ಕೆ ಬಂದಿದೆ. ಇವುಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಶೀಘ್ರವೇ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಅಧಿಕಾರಿಗಳಿಗೆ ಸೂಚನೆ ಕೊಡುತ್ತೇನೆ. ನೊಂದು ಕೋರ್ಟ್ಗೆ ಬರುವಂತಹ ಕಕ್ಷಿದಾರರಿಗೆ ಶೀಘ್ರ ತೀರ್ಮಾನ ಕೊಡುವುದು ಬಹಳ ಮುಖ್ಯವಾಗಿದೆ. ಹೀಗಾಗಿ ಈ 2 ದಿನದ ಕಾರ್ಯಾಗಾರಗಳಲ್ಲಿ ಒಳ್ಳೆಯ ರೀತಿ ಚರ್ಚೆಗಳು ನಡೆಯಲಿ. ಈ ಚರ್ಚೆಯಿಂದ ಬರುವಂತಹ ಒಳ್ಳೆಯ ವಿಚಾರ, ಜ್ಞಾನ ತಮ್ಮ ದಿನನಿತ್ಯದ ಕೋರ್ಟ್ ಕಲಾಪಗಳಲ್ಲಿ ಸಹಕಾರಿಯಾಗಲಿದೆ ಅಂತ ಹಾರೈಸ್ತೇನೆ. I once again assure you that Government of Karnataka will always support and facilitate judiciary to have a better justice delivery system in the state. With these words, I conclude my speech by thanking the organizers for giving me the opportunity to share my thoughts. Thank you. Dhanyavad. Namaskar.
We thank Honorable Chief Minister of Karnataka, Shri B.S. Yediyurappa, for his appreciation for the contribution of Karnataka State Legal Services Authority during the natural disaster in the recent floods, and also unflinching support, government support to the infrastructural development of the judicial system in different disciplines, and also his assurance on personal and human resource issues. Thank you very much, sir.
Ladies and gentlemen, it is Judge Washington who said, "The administration of justice is the firmest pillar of government." We have amidst us the doyens of such deliverance, a visionary and a mentor, Honorable Chief Justice Sharad Arvind Bobde, Chief Justice, Supreme Court of India. May I request Honorable Chief Justice S.A. Bobde, Chief Justice, Supreme Court of India, for his inaugural address. Sir, please.
The Honorable Chief Minister of Karnataka, Sri Yediyurappa, the Honorable Chief Justice of the Karnataka High Court, Sri Oak, my distinguished colleagues, Justice Shantangowda, Justice Abdul Nazir, Justice Bopanna, the President of the Judicial Officers Association, judges of the Karnataka High Court, present and former too, former judges of the other courts, judicial officers, the President of the Karnataka Bar Association, the Advocate General, senior advocates, members of the bar, ladies and gentlemen. It gives me immense pleasure to be here with you all today. I somehow do not wish to call this the Silicon Valley of India. It is a much, much older civilization. One of the prime centers of culture in India where I am. In fact, I am told a poet, Venkatappa Puttappa, called it, I hope I get it wrong, get it right, Bhudevya Mukutada Navamaniye. And I think it's because of this that Justice Mohan Shantangowda asked me to speak with this on. Karnataka has the proud distinction of sending many scholarly and distinguished judges, some of whom reached the Supreme Court of India. Justice Hegde, Justice Jagannath Shetty, Justice N. Venkatala, Justice Shivraj Patil, Justice P.V. Reddy, Justice Ravindran, Justice Syriac Joseph, Justice Santosh Hegde, and Justice Gopal Gowda. A few had the distinction of becoming Chief Justices of India. Justice Venkatramaya, Justice Venkatachalaya, Justice Rajendra Babu, and Justice H.L. Dattu. Through their erudition, expertise, and professional performance, they have made truly noteworthy and valuable contributions to the development of law and justice in India. I am proud to be here in Karnataka, which has produced so many fine legal minds. And as I see from what we do every day, it still produces fine legal minds. I was telling Justice Shantanu Gowda this morning that some of the best judgments in civil law come from Karnataka. And not only from the Karnataka High Court, some of the best judgments in civil law come from the Karnataka judiciary, the district courts. I don't know if we can really implement what your Chief Justice said about changing the nomenclature of judges. But one thing I do know, that if you keep aside these distinctions, differences in pecuniary jurisdiction, territorial jurisdiction of various courts at various levels, there is, to my mind, absolutely no difference in the task which is performed by civil judges in the district court, judges in the High Court, and judges in the Supreme Court. The task is one, and the task is to decide cases, to deliver justice. I have always thought that we in the profession and we as judges do not often realize our true position. It is very unique under the Constitution. Government means the Parliament and legislatures, the judiciary and the executive. Remember, your position is so unique that you are the only organ of state which has the power to decide any case, to apply any law to a particular case. Neither the legislatures can do that, nor the executive can do that. Only a court can tell a citizen that this is the law that applies to your case and this is how it should be decided. It is so unique that there is no comparison between the powers of the legislature, the powers of the executive, and it is therefore a task which we must take with great seriousness and which I am sure you all do. The importance of law, I do not wish to dwell on too much. It's too much. I believe that the foundation of civilization rests on law. And not only today, not only from the recent past, in India it has been an ancient rule of civilization. An early Upanishad says, law is the king of kings, far more powerful than they are. Nothing can be mightier than the law by whose aid, as that of the highest monarch, the weak may prevail over the strong. The pursuit of justice is the dharma of all judges and must at all times be guided by the constitutional dictate solemnly prescribed in the Constitution to secure to all its citizens justice, social, economic and political. As judges, it is our duty to ensure that this text of the Constitution transforms into reality. In light of this aspiration, the theme of the conference, judicial process, re-engineering and judicial skill building, is apposite. In fact, I find it very interesting that one of the topics in the Constitution is concerned, in the conference, is concerned with the impact of law on economic performance. This is a matter which comes daily before courts and we often do not realize it. Yesterday we had a matter in the Supreme Court, and I'm just telling you how what we do as courts has something to do with law. A question came up, and this is an undecided point. A question came up, how do you value a tree? Somebody wanted to cut many, many trees, some of them 80 years old, and some of them 100 years old. And one of the suggestions that came up, and I find it very interesting, is that you calculate the value of oxygen which a tree produces from the beginning till its entire life cycle of 100, 200 years. That oxygen also has a certain economic value. So when you consider the cost of a project, should you factor in the cost of the value of the oxygen which a tree produces? This is, in a very broad sense, the impact of law on economics, because the question is whether it should be built into the cost of project cost. Judicial officers have to deal with a variety of problems, and I find that one of the most striking things about judges is that they do what David Paddick says in his book. They do not have an easy job. They repeatedly do what the rest of us seek to avoid, that is, to make decisions. But judges do much more than take decisions. A judge is called upon to play a whole range of roles, including that of arbiter, mediator, counselor, sociologist, and as Justice Shantan Gowda pointed out today, even psychology. And in the midst of all this, adjudicate disputes presented to him in a manner that is cognizant of constitutional aspirations and social realities. Under our Constitution, the legislature can undoubtedly pass the law and the executive can frame regulations, but it is left, as I said, to the exclusive privilege of the judiciary to apply it to an individual case. The ever-increasing diversity and complexity of matters that the judiciary is called upon to adjudicate today is mind-boggling, and at times challenges the very limits of the system and its members. Conventional approaches are often found to be inadequate in the face of technology-fueled interconnectedness and demands an extra dimension to the judge's perception and equipment. You know, there is an explosion in knowledge and system of communication, and it warrants interdisciplinary approaches and analysis. Just yesterday, the Supreme Court pronounced on whether the internet can be a part of the freedom of expression guaranteed by the Constitution. These are points which the judiciary is being called upon to decide. It involves knowledge of constitutional law, it involves knowledge of technology. And a question is bound to arise whether that freedom, for instance, if there is a marriage pendal or anything, temple, mosque, anything which is loudly narrating or playing music through a sound system, a question could arise whether the utilization of a sound system is integral to the expression of freedom of expression. These are things which the judiciary is being called upon to determine daily, and evolving an understanding of human rights and democratic accountability provides new parameters for appraising judicial functioning in a society. Judges without adequate knowledge, skills and experience may cause distortion, delay and miscarriage of justice. That is why conferences like these, which discuss topics like these, are of utmost importance to the judiciary. In fact, you might recall what an old German jurist said about justice. He said the ultimate guarantee of justice is, in a court of law, is the personality of the judge. And that is what needs to be developed through such conferences. The gap between what is available and what is required in terms of knowledge, skills, specialization, perspective and aptitude requires a rethink on how we equip judicial officers to competently discharge their duties and in the process dispense justice. Mahatma Gandhi rightly said, the difference between what we do and what we are capable of doing would suffice to solve most of the world's problems. When it comes to justice administration, knowledgeable, skilled and compassionate judicial officers would achieve far more than inanimate rules and process can. It is the judicial officers that breathe life into inanimate process and procedures by ascertaining how they are to be operationalized. Any discussion reforming judicial process on a fundamental level must focus on judicial officers, because their improvement would have a direct and tangible impact on the judicial process as a whole. There is an axiom in management, and that may be relevant here. Any organization and its working is only as good as its people. At the same time, we must remember judges are not born, they are made. The quality of a judge and the quality of the judicial process in large measure is contingent upon the quality of learning and experience obtained by him. A key question therefore would be, how can we improve the quality of judges? A significant part of the answer lies in the nature and type of judicial education received by judicial officers. Judicial education is important because it enhances professional competency of the judiciary to perform its duties by enabling a mastery of legal knowledge, development of professional skills, and acquisition of judicial disposition. On a more fundamental level, by assisting the judiciary as an institution to effectively evolve and discharge its various constitutional roles. Judicial education secures judicial independence. And here I would like to reiterate what many speakers before me have pointed out today, that this is one thing which runs across every level of the judiciary. It is not a matter which is relevant only for the Supreme Court and the High Courts. It is important to realize that judicial education in India is often equated to judicial training. But education, I believe, is a much larger concept than mere training. Training would include knowledge of law, knowledge of procedures, how a thing is done, what is done before, what is done later. But education requires the growth and conscious development of all the qualities which we mentioned earlier. The goal of both may be enhancing professional competence, acquisition of knowledge in human and social sciences, and generating a deep understanding of socio-economic concepts, greater social accountability, and diverse institutional capacity building. In fact, Brother Nazir would remember that in a recent case which was decided by the Supreme Court and we were on the bench together, we had to deal with religious concepts, the value of archaeology, whether it is scientific or not scientific, what are land revenue, what are the land revenue records, and almost everything under the sun. It is an able bar which assists us, but judges must have developed knowledge of this. Walter Scott put it very pithily: a lawyer without history or literature is a mechanic, a mere working mason. If he possesses some knowledge of these, he may venture to call himself an architect. Judicial education must not only be theoretical, but also repetitive of law schools. It is a common perception that moot courts are organized only to train law students. I wonder if this method of moot court cannot be adapted to introduced to judicial academies for training judges. The question the judge should ask, a question a judge should not ask, are all matters which require training and education and which can be gone into in a moot court. We need practical instead of academic focus, applied instead of theoretical, and skill development instead of mere transmission of information. On a more philosophical level, judicial education must also cater to and fulfill the desire of the judges to maintain their identity with their profession and assess its direction. These would promote adherence to the highest standards of ethical conduct in both professional and personal life, elimination of bias and prejudice to secure integrity of the judicial system, and adjustment to new perceptions of justice articulated by changing context, values, and technology. Our powers under Section 89 of the CPC are not utilized sufficiently. And many times when they are utilized, they may not meet with sufficient success, like we experienced in the Ayodhya dispute. We thought that things could be solved by mediation. There were some problems, but this is something which is very important. Mediation is something that must be brought into the system. It does not affect the prospects of the bar, the earning prospects of the bar. When there are trained lawyers who are trained in mediation, you can in fact have a mediation bar which can charge the same level, if not a better level of fees for participating in mediation. Pre-litigation mediation is a need of the hour in the backdrop of a significant pendency that courts are tackling with. There are innumerable areas where pre-litigation mediation could solve the problem. The problems are very severe. This may not be the place to discuss all the problems. You can go into it in the conference. But people are staying away from courts. In commercial matters, interests run high. In criminal matters, people can't help going to courts, but people are fed up. And so many times there is a perspective which trial court judges may not have, but we in the Supreme Court need to have. Some people are in jail for 10 years, 15 years, and we are not in a position to deal with their appeals. The High Courts and the Supreme Court take so long. And ultimately, the courts feel that it is just to release them on bail. This is not a satisfactory way of looking at things. We must today employ every talent we have, every skill which we possess to ensure that justice is received within time, reasonable time. It can never be instant, and the delay in justice cannot be a reason for anybody to take the law into their own hands. But it is very important for us as courts to ensure that there is no undue delay in justice. We have a possibility of developing artificial intelligence for the court system only for the purpose of ensuring that justice, the undue delay is prevented. I must make it clear at the outset, since there are times when even judges have asked this question, the artificial intelligence is not going to replace human judges. It is not going to replace human discretion. It is only the repetitive, the mathematical and the mechanical parts of a judgment for which help can be taken of the system. Like you all know, the motor accident claims cases basically depend on the formula, the calculations under a particular formula. There are very few areas in such cases where the discretion of a judge is relevant, in areas like whether there was contributory negligence and such other matters. Sentencing obviously conviction and sentencing are matters which the human judge is going to do. But there is no reason to ignore the facility of artificial intelligence. I am sure some of you, our judges are very savvy these days, they work on computers, would know that the reading speeds which the artificial intelligence uses are up to 10 lakhs words per second. With this kind of system, thousands of pages can be scanned in a matter of seconds, and you can get the answer you want from the system. It is in this area that artificial intelligence can be useful, and we are exploring the possibility of implementing this. There are many others which obviously nobody has thought of, but I would request your Chief Justice to see that rapporteurs take notes of what happens in this conference and see what good suggestions come up, and please forward them to us for further action. The ideas which come from the subordinate courts, with your permission, you have made us conscious of using this term now. The ideas which come from judges of the district Cyril Asquith, son of a prime minister, said about the system of hierarchies. He said the ideal judge of the first instance is one who is short, simple and wrong. But this is not to say that the court of appeal should be long, tedious and right, because that would usurp the prerogative of the House of Lords. This is a conference which will have great promise. I am confident that this program would provide important learning points for all involved. With that, let me acknowledge and applaud the efforts of the Karnataka State Judicial Officers Association for their efforts in putting together this program. When I started work as a lawyer, a very senior lawyer came to me and said, "Don't make a long argument before the lunch break." I suddenly remembered that advice, and I will close now. Thank you very much. Best of luck. Jai Hind.
Honorable Shri Justice Sharad Arvind Bobde, Chief Justice of India, ಅವರ ಚಿಂತನೆ ಭೂತಕಾಲ, ವರ್ತಮಾನ ಮತ್ತು ಭವಿಷ್ಯದ ಹಲವು ವಿಷಯಗಳಲ್ಲಿ ಅವರ ಚಿಂತನೆ ಹರಡಿತು. ಅದರಲ್ಲಿ ನ್ಯಾಯಾಧಿಕಾರಿಗಳ ವಿಶಿಷ್ಟ ಶಕ್ತಿ, ಸತ್ವ ಮತ್ತು ಮಹತ್ವ, ಆರ್ಥಿಕತೆಯ ಮಸೂರದಿಂದ ಕಾಣುವಾಗಿನ ಪ್ರಕರಣಗಳನ್ನು ನೋಡುವಾಗಿನ ಸವಾಲುಗಳು, ಅಭಿವ್ಯಕ್ತಿ ಸ್ವಾತಂತ್ರ್ಯದ ಅಭಿವ್ಯಕ್ತಿಯ ಸವಾಲುಗಳು, ಇಂತಹ ಸೂಕ್ಷ್ಮ ಸಂವೇದನಾಶೀಲ ವಿಷಯಗಳನ್ನು ತೀರ್ಪಿಗೆ ಒಡ್ಡುವಾಗ ಬೇಕಾಗುವ ಬಹುಮುಖಿ ಬಹುಶಿಸ್ತೀಯ ಕೌಶಲ್ಯಗಳು, ಇವುಗಳ ಬಗ್ಗೆ ಮಾತಾಡಿದ್ದಲ್ಲದೆ ಮೀಡಿಯೇಷನ್ ಬಾರ್ನ ಅಗತ್ಯ ಮತ್ತು ಆರ್ಟಿಫಿಷಿಯಲ್ ಇಂಟೆಲಿಜೆನ್ಸ್ನ ಉಪಯೋಗ, ಹೀಗೆ ಇಂತಹ ಭವಿಷ್ಯಕ್ಕೆ ಉಪಯೋಗವಾಗುವಂತಹ ವಿಷಯಗಳನ್ನು ಕೂಡ ಅವರು ಪ್ರಸ್ತಾಪ ಮಾಡಿದ್ದಾರೆ. ಸೊ ವಿ ಆರ್ ಡೀಪ್ಲಿ ಇಂಡಿಟೆಡ್ ಟು ಯುವರ್ ಡೀಪ್ ಇನ್ಸೈಟ್ಫುಲ್ ಅಡ್ರೆಸ್, and we are sure that the following deliberations will really be guided by your insights. Thank you very much, sir.
ಆತ್ಮೀಯರೇ, ಹೊಸ ಯುಗಕ್ಕೆ, ಹೊಸ ದಾರಿಗಳ ಅನ್ವೇಷಣೆಗೆ, ಹೊಸ ಹೊಳಹುಗಳ ಅರಿವಿಗೆ ನಮ್ಮನ್ನು ನಾವು ತೆರೆದಿಟ್ಟುಕೊಳ್ಳಬೇಕು ಎಂಬ ಅದಮ್ಯ ಬಯಕೆಯೊಂದಿಗೆ ಇಂದಿನ ಸಮ್ಮೇಳನ ಆಯೋಜಿತವಾಗಿದೆ. ಈ ಕಾರ್ಯಕ್ರಮದ ಉದ್ಘಾಟನಾ ಸಮಾರಂಭಕ್ಕೆ ಆಗಮಿಸಿ ತಮ್ಮ ವಿಚಾರಶೀಲ ಚಿಂತನೆಗಳ ಮುಖೇನ ನಮ್ಮಲ್ಲಿ ಹುರುಪು ತುಂಬಿದಂತಹ ಎಲ್ಲ ಗಣ್ಯರಿಗೂ ನಮ್ಮ ಮನದಾಳದ ಕೃತಜ್ಞತೆಗಳನ್ನು ಸಲ್ಲಿಸಲು ಇದೀಗ ನಮ್ಮೊಂದಿಗೆ ವೇದಿಕೆಯಲ್ಲಿ ಶ್ರೀಯುತ ಎ ಸೋಮಶೇಖರ್, ಜನರಲ್ ಸೆಕ್ರೆಟರಿ KSGOA.
Good afternoon to one and all. I consider it my proud privilege to propose a vote of thanks on this historic occasion. Today, my words are not enough to express my sincere thanks. My Lord Honorable Justice Sharath Arvind Bobde, Chief Justice of India, is kind enough to accept our invitation. His Lordship inaugurated the 19th Biennial State Level Judicial Officer Conference. His Lordship also launched Karnataka State Judicial Medical Welfare Fund Scheme. By His Lordship thought-provoking address, a concrete platform has been set up for our institution. I, on behalf of Karnataka State Judicial Officer Association and on my own behalf, extend very heartfelt gratitude to His Lordship. Thank you, my Lord. I would like to thank our beloved Sri B.S. Yediyurappa, Honorable Chief Minister, Government of Karnataka, for all the words of wisdom that radiated a source of energy within us. We thank you, sir. I would like to extend my sincere thanks to Honorable Justice Mohan M. Shantanagowda, Judge Supreme Court of India, who always stand by us, guide us, lead us and motivate us. Thank you, my Lord. I extend heartfelt thanks to Honorable Sri Justice S. Abdul Nazir, Judge Supreme Court of India. My Lord is kind enough to accept our invitation in spite of His Lordship busy schedule. Your Lordship presence is an honor and privilege conferred on us. Thank you, my Lord. Every celebration is an experience. Honorable Sri Justice A.S. Bopanna, Judge Supreme Court of India, always stand by us in all our endeavors. I sincerely extend thanks to His Lordship for gracing this occasion. Thank you, my Lord. An event of this dimension cannot happen overnight. Wheels started rolling months in advance. We have been fortunate enough to be supported by our Honorable Chief Justice Sri Abhay Srinivas work. His Lordship has motivated in organizing this conference and has timely given guidance. His Lordship has extended fullest cooperation in conducting this conference. The concept of Medical Welfare Fund Scheme is the brainchild of His Lordship. I extend my sincere thanks to His Lordship for your presence. Thank you, my Lord. I thank all the Honorable former judges of Honorable Supreme Court of India. I also thank all the present and former judges of Honorable High Court of Karnataka. I extend my sincere thanks to Honorable Lokayukta and Upaloyukta who are present here and grace this occasion. My special thanks to Sri Prabhulang Navadigi, Advocate General, Sri B.M. Sheelawant, State Public Prosecutor, the Chairman of Bar Council of Karnataka for their presence. Thank you, sir. I extend my heartfelt thanks to Chief Secretary, Government of Karnataka, and Principal Law Secretary and other Secretaries of Government of Karnataka. A special thanks to Sri Rajendra Badamikar, Registrar General and other Registrars of Honorable High Court of Karnataka. I extend sincere thanks to all the members of District Judiciary. I thank Sri A.P. Ranganath, President Advocate Association, and Sri Gangadhar, General Secretary of Bengaluru Advocate Association for their presence. I thank the law students, print and electric media, police officials, court staff, and all various department officials. I thank all the distinguished innovators present over here. Thank you, one and all. Jai Hind, Jai Karnataka.
We also thank Sri Somshekhar, General Secretary, Karnataka State Judicial Officers Association, for his wonderful vote of thanks. We would like to conclude this inaugural session with a famous quote of renowned poet and Nobel laureate William Butler Yeats. He said, "Out of the quarrel with others, we make rhetoric. Out of the quarrel with ourselves, we make poetry." This is also true in the realm of justice. May the justice become the poetry of truth. May the justice become the poetry of truth. With that aspiration, we conclude this inaugural session. Thank you very much, sir.
ಇದೀಗ ರಾಷ್ಟ್ರಗೀತೆಯೊಂದಿಗೆ ಕಾರ್ಯಕ್ರಮ ಮುಕ್ತಾಯಗೊಳ್ತಾ ಇದೆ. ಪೊಲೀಸ್ ಬ್ಯಾಂಡ್ನಿಂದ I request the dignitaries on the dais to kindly oblige for a photo session with the office bearers of the KSGOA.